and for pregnancies of fertile abnormalities. We are now among the countries with the highest upper gestation limit, and that is truly commendable. However, there are certain issues that I would like to bring to the attention of this government, especially the Honourable Health Minister and the Honourable Law and Justice Minister. As it stands today, abortion is criminalized under Section 312 of the Indian Penal Code, except under the provision of MTP Act 1971, and that is and its subsequent amendments. The first and foremost, India must decriminalize abortion. Criminalizing abortion is not only a mark of our legal system's perplexing and continued post-colonial hangover, it is also the infringement of a woman's reproductive rights. Right now, the rule is that abortion is criminal, and the exception to the rule is MTP Act. We must make access to safe abortion the norm. We may, of course, seek only to criminalize abortion in certain exceptional circumstances, such as abortions performed without the consent of the pregnant person, as well as the sex-selective abortions. Criminalizing stigmatizes abortions and those seeking it, thereby hindering access to medically safe abortions for young girls and women from marginalized populations of this country. This stigmatization forces women to seek unsafe abortion, which are often carried out at unregistered facilities by unqualified practitioners. This is especially true because medical practitioners are likely to perform even legal abortions due to fear of persecution. This reluctance by medical practitioners explains why women and girls continue to seek judicial authorization for even those abortion procedures that are legal. The biggest issue with the particular bill is that our abortion laws are doctor-centric and do not consider abortion as a fundamental right. The bill places the onus on the doctor or registered medical practitioner to determine the legitimacy of a woman's request to terminate her pregnancy. It does not pay heed to the fact that legal, safe abortions are women's fundamental right as held by Article 21 of the Constitution. In a landmark judgment, landmark 9-bench judgment, the Supreme Court of the Supreme Court of India in case Puttaswamy versus Union of India, Justice Chandrachud stated that the right to make reproductive choices is a woman's constitutional right. And that right is integral of a person's liberty under Article 21 of the Constitution. I will take one more minute and I'm concluding, sir. B. Justice Chandrachud states that family marriage, procreation and sexual orientation are all integral to the dignity of the individual. Similarly, Justice Chamleshwar, in the opinion, unequivocally stated that women's freedom of choices whether to bear a child or abort her pregnancies are areas which fall under the realm of privacy. Finally, this law should apply to pregnant persons and not just pregnant women. Sir, I repeat this. This law should apply to pregnant persons and not just pregnant women. The proposed legislation uses the word women throughout. Whereas access to safe abortion is critical for transgender, the bill that you have just passed, giving them rights as individuals, and intersex and gender diverse persons. Therefore, I suggest that the word women should be replaced by persons. In conclusion, Honourable Health Minister and the Honourable Law and Justice Minister, I believe the time has come, the time now has come for India to be among the stalwarts of the reproductive rights movement, keeping the autonomy of Indian women's and gender diverse person in mind. India's abortion law must be completely redrafted with the gender, justice and public health access framework in mind. Thank you very much.
Thank you, Srimati Rajshri Malik.
Thank you, Chairman, sir.